You are inviting anarchy and chaos, and that is subversive of national security. I'm involved in some of the cases, and particularly the saddest one. I'm not a Muslim. I don't pretend to be one. But I got a brief in my office where 347 Nigerians were massacred in Zaria in December 2015. Not only that, their leader, Zaki Zaki and his wife, who were not at the scene of the incident, were shot at. 3 of their children were killed in their presence. But they didn't die, luckily. But since then, they have been detained. And this is the first time since 1914 that we have had the detention of a couple. Never. I mean, neither Ghanaian or myself or any of us had our wife detained with us. But this man is being detained with his wife. We went to court. And what did the government say? We are detaining him for state security. In fact, they also went further. When that couldn't work, oh, we are keeping them in protective custody. And the court said, do they have Ebola? That you are castrating them. And the court, on 2nd of December 2016, the court ordered their release. They are still in custody. When the government could no longer defend their detention, they were charged with murder. That same offense, 100 people have been charged for that offense, and they have been discharged and acquitted. Those who violated national security by killing 347 people have never been brought to court. Now, do you justify detention or disobedience to court orders under democratic government? I'm very happy I was reading the PDP this morning, waxing eloquent with respect to the rule of law. And I said, do these guys think we have forgotten what happened? Under President Olusegun Obasanjo, the greatest violation of the rule of law took place in Nigeria when the judgment of the Supreme Court was disregarded. I'm sure you know about the case of AG Lagos and AG of the Federation. It was President Yar'Adua who complied with that order when he came on board. But I can tell you today, all the governments in Nigeria, Abuja and all the 36 state governments, have contempt for the rule of law. And our colleagues, because we must say this, our colleagues who are attorneys general, connive with the governments. Again, you can quote me on this, including President Buhari. There is no president or governor who would not seek the legal advice of the Attorney General if confronted with obedience to court orders. It is our colleagues who will advise. We don't need to obey the order. A governor told me, I challenged a governor, why are you not obeying this order? He said, Mr. Fallon, I was told by my Attorney General that you are likely to go on appeal against the order you have obtained. If you win at the Court of Appeal, we shall go to the Supreme Court. And before you finish, we will have left power 8 years. Now let me just conclude.
Thank you.
By quoting to you what the Supreme Court said in the case of Garba and Federal Civil Service Commission. The military in coming to power is faced with the question as to whether to establish a rule of law, a rule of force. While the latter could be justifiable, a rule of terror, once the path of law is chosen, the mighty arm of government, the militia, which is embodiment of legislation and executive, must in humility bow to the rule of law thus permitted to exist. The rule of law knows no fear. I'm quoting Justice Esho. It is never cowed down. It can only be silenced. But once it is not silenced by the only arm that can silence it, it must be accepted in full confidence to be able to justify its existence. This bar, Nigerian Bar Association, once went on strike to protest the disobedience of a single court order. But today, the NBA is so comfortable with disobedience to court orders. Now, please, distinguished colleague, I'm going to sit down now. For us to understand what a court order means, an American president, and this is very important for all of us, an American president was confronted with a single disobedience of a court order in 1957. I'm sure you are aware of the case of Brown and Board of Education, which had abolished segregation in America. So one of the white states, just like this president will do now, Trump, a governor went to a school. You will not admit any black students in this school. And went with a number of people, a mob, to prevent the admission of 9 students. The American president in Washington was on holiday. He went back to Washington to make a broadcast. And I'm talking of President Dwight Eisenhower. You know what he did? He placed 10,000 troops, National Guard, put them on alert, and sent to the secondary school in Arkansas 1,200 troops to enforce that single court order. And until those 9 students that were prevented from gaining entrance to that school were admitted and assured that there would be no racial harassment, those troops never withdrew from that country.
Thank you very much, Mr. Falano.
So,
we must end, Mr. Falano.
In our own country,
Mr. Falano. Members of the bar, Mr. Falano believes very much in the rule of law. He doesn't like the rule of rulers, or the rule of communists, or the rule of human rights leaders. So the rule of law is that he had 7 minutes, his time was up, and so we have to respect that. And there's another speaker who will like to listen to. Mr. Falano's paper is available online. There's an app that has it. So now, ladies and gentlemen, Mr. Falano, thank you very much. Indeed, great insight. We can see the battle scars, but you're not the only one with battle scars. Kirsty Brimlow also has battle scars from another jungle, Colombia, and has great insights for us on the rule of law and security. And I'm sure she has perspectives on some of the things that we have this morning and some of the things you've had since Sunday. The floor is yours. 7 minutes. Thank you. I'm sure you respect the rule of law.
Well, that's quite an act to follow. I'm going to try and speak in 4 languages. Okay? Ekaro, Inaguana, Odima. Good morning. Thank you to the NBA for the invitation to speak. Thank you to the NBA executive, and thank you to, I'm going to call him the current president, I don't like outgoing, current president, Abiy Mahmoud San, for his dynamism and creative thinking in the partnership between the Bar Human Rights Committee and the NBA. So I can report that the training in international human rights that we've been carrying out, I can report that it has been free of adjournments. It's been free of attempts by lawyers to collapse it through technicalities, and the training has been successful. I'm delighted to see so many trainees here. Please put your hands up. There's a number of you here. Thank you. Now, terror. Terror. Well, terrorism, I had a look back on the history. Now, terrorism has a name which is rooted in Latin, terrere, and it means to make tremble. But what's important is it's not a new threat. Also, it's often overlooked that there are two broad categories of terrorism. There's bottom-up terrorism and there's top-down terrorism. Another way of describing top-down terrorism is state terrorism. Something, again, that is often overlooked is that there are far more victims of state terrorism than there are of bottom-up terrorism. It probably had a very inglorious peak, state terrorism, in the 20th century. I'm going to skip through fairly rapidly just to make my point on state terrorism. The early governance was in despotic regimes, for example, in China in the 3rd century, which went from 3rd century to Mao Zedong. If you look at the societies of the ancient Orient, India, with one exception, the Islamic empires, they had a similar way of dealing with disorder or expression. They dealt with it by injustice. And then the last of these different regimes was the Ottoman Empire, which unscrupulously used terror on its people. The embryonic democracies of Switzerland, the UK, the Netherlands, and the US, and also France, were not lacking in their own terror. In the UK, the Star Chamber was the worst, and it's now become a reference point for lawyers. A reference point for lawyers of torture, of use of extraction of confession, of lack of due process, of lack of open justice, of a place we would never want to go back to. And it was abolished only in the 17th century. The 20th century, moving forward, we're all familiar with the Nazis, Nazism. 6 million Jews lay slain at the end of World War II. We're familiar with Stalinism and terror and Stalin's show trials, which meant nothing. In fact, Churchill looked at the dead and murdered Jews and said, what name can I give this? There's no legal name for it. And genocide, in fact, did not exist to him at that time. We're now familiar with it. Historians amongst you, it was a Polish law professor called Raphael Lemkin who first coined the phrase, although Churchill, I think, tried to get credit for it, but it wasn't him. Bottom-up terrorism, that obviously exists. Now, quickly on that, again, this is as old as terror itself. It's as old as fighting itself. And it's long been used by religious groupings. So you had the Thuggis in India who worshipped a god called Kali. And what they did was they trained children in the dark crime of strangulation. So children would strangle passing travelers and use that sacrifice to feed the goddess. The British only started dismantling that particular sect in the 19th century. Nigeria. Nigeria declares, I've seen it written, that it considers that terrorism is a fairly new concept that it's had to deal with. But again, this isn't right. Nigeria has a history which is violent. Its history consists of ethno-religious clashes, inter-ethnic violence, intra-ethnic conflicts, and religious crises. All has been called extremism, uprisings, riots. But really, it's been terror, but just with different names. Examples, you'll be very familiar, the movement for the emancipation of the Niger Delta People's Volunteer Force, the Maitacene riot of 1980, the Odi massacre 1999, where 2,500 people were killed, the village was razed to the ground. Jelwa massacre 2014, 700 people were killed. Boko Haram, well, there's no doubt as to the atrocities committed by Boko Haram. More than 20,000 people have been killed by the insurgency. Approximately 2.1 million people have been displaced, and 7 million need humanitarian assistance. There's also nothing new, and I'm coming on to Buhari, your president's comments, very shortly. There's nothing new in governments devising ways of dealing with this type of crime by sidestepping due process. The Star Chamber was our shame that we still refer to whenever there is creep within our legislation to shut down public justice. I was, in fact, a very long trial that I represented the defendant in still remains the only case in the UK where the murder was tried in camera, in secret. And that was described as a sad point in history. There's also a well-worn phrase, and we've heard some of this probably this morning, really look at history. Why? Because history repeats itself. However, if it were that simple, we would not make the same mistakes. Because what happens is history shape-shifts. It's not recognizable. It disguises itself in different ways. It's smoke and mirrors. So it's harder for us to recognize and learn lessons from the past. Now, Nigeria and terrorism. It was very late in bringing in its Terrorism Prevention Act. It was some 10 years after the UN Security Council resolution which set out that states must domesticate laws against terrorism. And we know it was a rushed act, the 2011 Act, but also that's evidenced because within 2 years, about 20 or so provisions were entirely amended and replaced in the 2013 Act. I don't perhaps have time here, but there are a lot of issues with your Terrorism Act. We also have a lot of issues in the UK. We have a new bill going through, which I'm quite involved with, which is criminalizing thought. Now, the atrocities committed by Boko Haram really hit the international world with the kidnap of the Chibok girls, over 270 girls, and that was April the 14th, 2014. It hit my consciousness much earlier, 2011 in particular, with the bombing of the UN house in Abuja. I still have my pass from that UN house. Mohammed Yusuf, the leader of Boko Haram, was brutalized and killed in police custody in 2009. And what his death has illustrated is that even one act of impunity will instigate a further and deeper and more vicious cycle of violence. Professor Akin Oyebode said the following: "Where and when every member of society is assured of his day in court, there would be no room or justification for terrorist acts. However, denial of justice and resort to terrorist acts by the government itself could well provide much needed ammunition to forces that do not wish it well, and who may now insist on a policy of fighting fire with fire. We cannot let that happen in Nigeria." The UN Special Rapporteur on IDPs has already written as to his concerns as to the conduct of security forces within Nigeria in dealing with internally displaced persons. He's spoken of the mass arrests, the prolonged detention without charge, the misuse of powers, and further, the lack of humanitarian assistance given and the lack of dignity given to those people who are kept in appalling detention conditions. This leads me to the President's remarks at the opening of this ceremony. For me, they were deeply troubling. He said as follows. He said, "Law can only be optimally practiced in a Nigeria that is safe, secure, and prosperous. This is clearly wrong. Law should be functioning at its optimum when a country is unsafe, when it's insecure, and when there is poverty. This is the testing of its strength, and this is the of law to those who most need it.
Thank you very much, Christy. On that great note.
Final point, important point on what he said. It's already been said on the rule of law, national interest, national security. My view is what he said was extremely dangerous.
Thank you very much.
Finish. And 30 seconds to finish why. 30 seconds to finish why. It is important. The rule of law is such that Nigeria, the government and the president, the international conventions, that it will be bound by international law. If there is a state of emergency, that must go to the National Assembly institution. What cannot be done is say that national security or public interest are such that those rights are there in order to safeguard the functioning of a proper judicial system within Nigeria. I'm going to remind President Buhari.
Civil rights again. I thought the rule of
Chief
law
Executive, you make your comment, sir. Chief Executive, please. Chief Executive, come ask the question, Chief.
Yeah, okay, fine. The question I want to ask is, when there is a deliberate misinterpretation of the judgment of the Supreme Court in Asari Dokubo, which merely talked about human rights.
Oh, thank you. Thank you very much, Chair. My name is Afyong El Afyong from the Kejab, and my questions are directed to Mr. Falano and Madam Kirsty, Barrister Kirsty. And I wanted you to comment on the question of terrorism, say by the British, for example, and other European nations, because we hear a lot of things about the Nazis, you know, Boko Haram and all these other people. But I wanted your comment on the terror, on the question of terrorism, of slavery, specifically the transatlantic slave trade, and of course the trans-Saharan slave trade. Bearing in mind the fact that slavery was actually legal and, you know, under this issue of the rule of law. Also on the question of the terror of slavery on the American plantations, and that also was a legal regime, especially in the United States of America. And lastly, the question of the terror by specifically the British government against Africans during the era of colonialism. And an excellent example would be, you know, the experience of the Mau Mau in Kenya, and also even the experience of women in Nigeria that provoked, you know, for example, the Aba Women's Uprising. So I think that we also need to bring this kind of issues under questions of terror, you know, and explain them as lawyers, because these are all legal regimes, okay, and the fundamental contradictions that they throw up. Thank you.
This side of the hall, the gentleman, yes, sir. Yes. And that will be the last question.
My name is Ngozi Olehi. I belong to the Owerri Bar. I am sorry, I am still confused, and I am sure many of us are, because the rule of law that we are talking about seems to be very amorphous. In other words, the promotion of the rule of law, which is our motto, is different from the rule of law, which the president was talking about, or could be different also from the rule of law talked about by the World Justice Project, which ranks Nigeria annually at the rear after global ranking of countries. So what is actually the problem? Number two, please, the key to stability is jobs. The key to jobs is investment. The key to investment is the rule of law. Please, can you clarify? Because with the nexus of rule of law to economic development, and which we don't give any consideration about,
Thank you.
These are my questions.
Thank you. Yes, sir. Mr. Just a minute, replies, and then we close.
For me? Okay. First of all, Chief Michael Zekome is saying, I think we should get something clear. The point made by the president has long been captured in the Latin maxim, Salus Populis Suprema Lex. The law of the society will take precedence over individual liberty. Where we can depart from the president is the attempt, whoever wrote the speech, to use the case of Dokubo Asari versus Federal Republic of Nigeria to justify disobedience to court orders. In that case, Justice Tanko made the point that it's only when you have peace that you can talk of your individual liberty. But if the country is in pieces, you can't talk of human rights. And nobody can dispute that. But who defines national security? It's the court. Section 45 of the Constitution has provided that many of those rights in Chapter 4 can be suspended in the interest of defense. Even when you have a case involving children in court, you can send everybody out in the interest of the child. You can't talk of public hearing. So the law is very clear on this. As for the office of Attorney General and Minister of Justice, I've always argued that both have to be separated. One is a politician, one is a professional. We have not been able to draw a line of dichotomy. And thinking about justice, that is the problem. I wrote to the NBA, please, can we begin to sanction our colleagues who refuse to prosecute murder suspects? Because many of us will say, oh, Buhari is not prosecuting headers because they are Fulani people. Nonsensical. Please, it is the duty of the Attorney General in each of those states to prosecute those who have been arrested by the police and the army. But because our colleagues are not doing their work, we are in trouble. On the last point on transatlantic slave trade, unfortunately, and I do hope the NBA will be interested in this, there is an African court on human and people's rights in Arusha, Tanzania. Nigeria is one of the countries that has refused to accede to the instrument to allow victims of human rights, particularly outside Nigeria, to access the court. In the case of Libya, it takes two to tango. All the victims that were brought back by the government could have gone to that court to say I was enslaved in Kenya. But what we are doing with the African ECOWAS court here, and the man who came, the president of Ghana that came to address us on Monday, I phoned him about 3 months ago. President, we are friends. I don't want to embarrass you. I have a judgment in the ECOWAS court that you should pay a Nigerian $250,000 because a 14-year-old Nigerian boy was drowned in Tema during an excursion, a secondary school boy. But because the government did not investigate, the ECOWAS court said the government must pay. We're on that. Madam, in the case of UK, sorry, sir. No, Maumau victims. It's very important for our colleagues so that we can make money through these cases. 19.4 million pounds have been awarded for victims of Maumau operation. Thank you.
Thank you,
sir.
Thank you. I completely agree with taking cases to the ECOWAS court, and there's some very good judgments there. Not enough lawyers are doing it. Very briefly, 3 points. Separation of powers are very important. You need to make sure your AG, as a political figure, is in a position where you have a counterbalance of somebody, we rely on a DPP to be independent of the AG and set things straight where there is a political spin put on a case so that the information is put across accurately as to what that case is actually saying. And we as lawyers also have responsibility to set right what is said in judgments. So there needs to be a look at separation, constant changes with the government structures. On UK and so on, I'm very familiar with the Mau Mau case because, in fact, my colleagues at my office took that case against the UK government. I had many more. The Nama Herero case I'm in at the moment, representing those people in Namibia who were slain by the Germans in 1904 to 1908. There's many examples of top-down state terrorism. Slavery is one, and there's many examples in history where rules are made in order to somehow keep that kind of conduct. We've evolved, and where we see it there, we challenge it within the court system. Finally, on rule of law, it's very straightforward. The rule of law is a series of laws. Now, international law came in after World War II in order to say to states that you cannot be trusted how to look after your own citizens. The Constitution is a reflection of international law, and so you should be holding your government to account that under the ICCPR, under Article 14, no matter what is happening, a fair trial is guaranteed to somebody. It's an absolute right. There is a right that somebody is not arbitrarily detained, Article 9. You have the same domestically. It's straightforward in the states where there's been no suspension. In the states where there is suspension, point on this, very important, you cannot ever derogate from the obligation not to commit torture against your citizens, even if there is a state of emergency. So the laws are there, and they need to be enforced, and we all need to do more to speak truth to power.
Thank you.
And finally,
the last word will be from...
Finally.
Yes, sir. Last word from Professor Sulu Gambare.
Yeah, thank you. Very briefly, 3 points. Is this working? First, it's not a choice between respect for the rule of law and the promotion of national security. And the point I was making is that the concept of national security, broadly defined, has to have the rule of law as part and parcel of national security. Because if you talk about the physical security of the state or the security of a particular government, then you might have that secured, but the insecurity of the people. For full security of the people, which is ultimately national security, the rule of law has to be respected. But I agree with Falana is that, you know, it's not that by all means, even if the state collapses, we must have rule of law. No, but the Constitution respects exception, suspension, but the question is who should determine exactly that. Second point, that the enemy of the rule of law, please, is not just the executive. You know, we have a national elite in the legislature, in the judiciary, that are subverting the rule of law at all times. So it's easy to blame the executive. The rule of law is far too important for it to be left only to what the executive does or does not do, the legislature, the judiciary, and all of us. And the third and final point is that this topic is so important that SA and Falana suggested, and I've taken the suggestion that my Savannah Center for the link between peace, development, and human rights and democracy will have a full one-day discussion so that we'll come up with recommendations that will address all the aspects of this issue. Thank you very much.
Thank you very much, sir. Ladies and gentlemen, yes,
Ben.
Ladies and gentlemen, I am sure we have learned a lot. We're a lot wiser. In summary, there can be no security without the rule of law, and I think that sums up all that we've said. Second high point, which we distill from what Mr. Falana said, is that we as lawyers have great responsibility in ensuring that the rule of law is obeyed. I know that Chief Olani Pekun here, one of our past presidents, has had occasion to speak in the public as to the importance of the rule of law and the executive obeying court orders and not dribbling around what the courts say. Because, as he says, ultimately, they themselves rely on the rule of law. So, ladies and gentlemen, once again, a round of applause for our great panel, as I ask the President and past presidents to please come on stage as we present gifts to our panel of speakers, and photographs are taken. And also the chairman of TCCP and other leaders of TCCP.
Mr. President, sir, we have a token for our guest that will be presented by your humble self. It is a made in Nigerian product, sir. Yes, sir. And then Chief Olas Nikpekun to present to Mr. Femi Falana SN. Thank you very much. We thank all the audience.
Well, ladies and gentlemen, so we now have our various breakout sessions. Continuing in this hall is a special session with the Chief Justice of Nigeria, who is ably represented by the digital judge, the Chief Judge of Borno State. Someone will come up very soon to bring up the panel. In Maki 1 will be a session on technological disruptions, one which you'll find very interesting. In Maki 2 will be a session on institutionalizing the war against corruption by considering new approaches to assets tracing and recovery. And the other session, which will be in Maki 3, will be on emergence of disruptive technology in legal practice and legal education. Good morning.
Distinguished colleagues, for those who are interested in the session on asset tracing and recovery, we are starting now at Marquee 2. Asset tracing and recovery at Marquee 2. Thank you.
Let's settle down for the next session. This session is about to start. Please let's settle down. We'd like to invite the panelists to come up stage. There's a special session organized by the African Bar Association, section on international law, going on at the Executive Hall. So if you're interested in that session, please move to the Executive Hall right now. It's starting immediately. It's a section on international law, organized by the African Bar Association. Yes.
Members of the bar, please can we settle down? Please can we settle down? Please, people in the aisle and in the front should please kindly sit. The panel is ready to begin. The Chief Justice of the Federation is seated, acting through the Chief Judge of Borno State. Yeah. Please, can we sit down? The photographers should please kindly. Can you leave Chief Malam Yusuf Ali? And please let us sit down and kindly.
Justice of Nigeria, Honorable Justice Walter Samuel Nkanu Onogen, GCON, Chief Justice of Nigeria. My Lord, the Chief Justice is ably represented today by my Lord, the Chief Judge of Borno State, Honorable Justice Kashim Zana. Thank you, sir, for coming. As the chairman of this session is Chief Wole Olanipekun, Senior Advocate of Nigeria, former President of the Nigerian Bar Association. My Lord, thank you, sir, for coming. And we also have as a panelist, Mr. Babatunde Fagbonlu, a Senior Advocate of Nigeria as well. Thank you, sir. We have all the way from Cairo, Egypt, Dr. Ishmael Salim. He's a director with the Cairo Regional Center for International Commercial Arbitration, the CRICA. Thank you, sir, for coming. Shortly before I hand over to our able chairman, we received a message from the Chief Justice of Nigeria. Let's have a listen to that. A slight correction there. It would be played while the representative of the CJN is giving his remarks. So may I humbly hand over the session to our able chairman, Chief Wole Olanipekun. Thank you.
May I welcome you all to this session. My Lord, the Honorable, the Chief Justice of Nigeria, ably represented by the digital Chief Judge of Borno State, our brother, we know him, all of us know him. I will still say a word or two about each of the panelists. The topic itself is access to justice. Access to justice. Whatever we have been doing here since the beginning of this conference is captured by the topic. The topic is all embracing. Whether you are talking about the rule of law, you are talking about liberty of individuals, you are talking of constitution and constitutionalism, everything, and I dare say and repeat, everything is captured by access to justice. The immediate speakers address us on a lot of issues, including whether or not rule of law should give way to national security, whether or not the rule of law should give way to exigencies, democratic or otherwise. But all of them, and all these issues which agitate our minds, will be discussed by these panelists. Access to justice, for, to my mind, it's all trash, rubbish. Maybe you can even sell them to the Marines. You have rule of law, you talk of national security, you cannot gain access to justice. What are the costs for? What are the costs meant for? How do you ventilate your grievances? It's because it's only if you have access to justice. I don't want to preempt the speakers. And at the appropriate time, I might make some references. But let us prepare our mind and bear in mind what Lord Atkins said in that popular case, that whether we are in war, whether we are in turmoil, whether in battle, that the rule of law must be espoused, it must be respected. Here in Nigeria, during military and militarism, military governor of Lagos State against Ojukwu, what has Supreme Court said? I don't know as much as the panelists, but let us bear in mind that the organizers of this conference has done well by making the Honorable, the Chief Justice of Nigeria, the lead speaker and presenter. Let us be reminded that the head of the legal profession in Nigeria is the Chief Justice of the Federation. He heads the Supreme Court. He's the chairman of the National Judicial Council. He's chairman of this and chairman of that. And all of us as lawyers, we get enrolled as barristers and solicitors of the Supreme Court of Nigeria, not of the Court of Appeal, not of the Federal High Court, not of the State High Court, but of the Supreme Court of Nigeria. He is the custodian. The Supreme Court is the natural habitat where each and every one of us enrolls. I want us to be very attentive, and I want us also, let us cross-fertilize ideas on this access to justice topic and use it as a point of contact for everything that we have been doing and what we'll still do at this conference this week. And also, I want to believe that my president, our president, the president of the Nigerian Bar Association, the highly respected A.B. Mahmood Esquire, and the incoming, that they are here. Because when you talk of the rule of law, you don't play Hamlet without the Prince of Denmark. What is the role of the Nigerian Bar Association? I don't know whether any of the panelists has anything in mind to say about it. The Bar Association, you are the carrier. You are the anchor. We have to remind ourselves what MBA should stand for at all times and in all seasons. Not just for lawyers, not just for bread and butter, not for dinner, not for jamboree, not for picnic. We have to remind ourselves of the days of yore. Who were the presidents of the MBA? What were the MBA? What were they saying? Not that MBA will just say we see nothing, we hear nothing, we feel nothing. MBA must talk. Some of the things that the panelists here are saying are things that should be said by the MBA. It's not a question of you folding your arms and just watching. I want to welcome each and every one of us here. My Lord, the Honorable the Chief Judge of Borno State, we all know you. We know your worth. You are very articulate. And we trust you. We believe in you. It's a topic that is so dear to you, so dear to us. It's the very essence of our profession. You are given 20 minutes, my Lord. I'm sharing here. I don't know, I'm not committing any content by restricting you to 20. I appear before the Supreme Court. My Lord, the Chief Justice of Nigeria will say, Chief Olanikwekun, 5 minutes. 5 minutes. It's a pity my Lord is not here because there is a request I want to make on behalf of the Nigerian lawyers, and you will pass that one to him as well in respect of access to justice. And that one later on when you might have made your representation. My Lord, the Honorable Chief Judge, for now representing the Honorable the Chief Justice of Nigeria, you are welcome to the podium. Thank you.
My President and Chairman of Session, all the array of dignitaries that are making me jittery, please accept my salutations in the appropriate order of protocol. I must admit, first I must extend the apologies of His Lordship, the Honorable Chief Justice of Nigeria. The entire matter reached him late when he was already committed elsewhere. And I got this marching order to come in and stand in and wear his really big shoes at this big occasion. In fact, his shoes are bigger and taller than mine in law. The material handed over to me said the lead speech of His Lordship is on access to justice and how to use modern processes and technology to to escalate justice delivery. That is all I've got. So the access of justice was qualified to how to utilize modern processes and technology in order to, the word used was escalate justice delivery. What appears as the topic, oh, that's why I really prefer to manipulate. Do you have a clicker? I get really thrown off when I see my slides going ahead of me. If you don't have a clicker, then wait for me to ask for the slide. It's clumsy, but at least that works better. Now, the topic as you see it here is my idea of what was meant by that email, a printed email message that I got. That is leveraging technology for enhanced access and delivery of justice. Now, being able effectively only to address this as from 7:30 p.m. yesterday, I thought very hard and I realized that the best way is to represent His Lordship is to come to this occasion and open up what the judiciary is up to in the light of this topic. That is, what it is doing to enhance access to justice and how the judiciary is leveraging technology to enhance access to justice and for effective justice delivery. Now, some of you are, I'm sure, very much aware, because I remember I spoke about the legal email project in this very hall on a similar occasion years back. We'll come to that. But that was only part of a package that the judiciary conceived and has been implementing. Now, the judges amongst you here may be aware of it. Some may not even be. But there is a judicial information technology policy in place which is being implemented. And I think it is most useful for us to appreciate, to understand what is going on, because without the bar's involvement, active involvement, it cannot work, it cannot succeed. So, by and large, what I'm going to do on behalf of His Lordship is to now open up and show you what the judiciary is up to in terms of rolling out and leveraging technology in order to enhance access to justice and also concomitantly, indeed, enhanced delivery of justice. Now we can have the second slide. My President, I don't need 20 minutes. I would rather even do it faster so that questions and answers will take our time, because this is one area where the more understanding and commitment we have from the bar, the more our chances of success. Now, without taking too much time with the preambles or the preliminaries, it is clear that we are in the digital age and have been since, it's okay now, since the year 1980, some say. We may have been slow in coming, but I think there's no denying the fact that we here in